Hi, I'm attorney Josh Berkeley.
And I'm Amy Oliver. We're the two attorneys here at Berkeley Oliver. I'm really glad you guys came in today. We want to talk a little bit about basic estate planning.
3 documents you need to make sure you have in your basic estate plan is a last will and testament, a power of attorney, and a healthcare surrogate designation. These documents are going to make sure that your wishes are carried out and that you don't incur undue expense later.
So one thing that we like to tell our friends about are some of the pitfalls that you can come up on. So we all have aging parents, and sometimes they may need long-term care, or they may have dementia or early Alzheimer's. And when they reach that point, they really can't sign legal documents. So one of the documents that we prepare, the power of attorney that Josh mentioned, will help carry on and allow whoever they appoint, usually it's their kids, to handle any financial aspects of their billing, their bill pay, or handle anything that they need to do for their finances.
All too often, people don't come and talk to us about something like a power of attorney until it's too late.
Yeah.
We'll get the call that says, oh, mom has fallen and broken her hip and she's going to need a nursing home next week. It's going to be a very short-term thing. At that point, if mom's cognitive abilities are okay, sure, she can still do some legal planning. But in many instances, we're in a position where we're in stages of dementia or Alzheimer's, and we no longer can have them execute legal documents. They're not able to from a legal capacity standpoint. When that happens, there's nothing left to be done. If they can't sign themselves into an assisted living or a nursing home, there's nothing else to do but to go to district court if you're in the state of Kentucky and apply for a guardianship, which is something that Amy does.
Josh handles the pre-planning. When things have to go to court, they typically come to me. Guardianship court is not a fun thing for families or for the individual who may still understand a lot of what's going on, but doesn't have all of their faculties. You have to have a petition. You have to sign and tell the district court judge why you think this person needs guardianship. And then the judge has to appoint an interdisciplinary team, which is a team of 3 professionals. You've got a physician, a mental health professional, and a social worker, typically from the state. They have to then come out and talk to mom, dad, grandma, whoever, and they have to prepare reports. And this can take anywhere from 30 to 60 days to complete. So sometimes you might have some downtime, or you might not be able to get mom or dad into that facility. It can be a jury trial, but it's a trial, and it does take away some rights. I like to call it the nuclear option because it takes rights away from that individual. So when you think, oh, I can drive, I can sign my own documents, I can vote, those are some of the things that you can lose in guardianship court.
And that's often one of the things that people are concerned about with a power of attorney is they think they don't want to do that, or we'll have people tell us, oh, I'm not sure I want to take that, I do that right now, I don't want to give up any of my rights. You're not giving away anything with a power of attorney. You're just adding, I like to say, like a dual steering wheel. Okay, so if you appoint your son as power of attorney, he can sign bank documents for you, but you can still sign for yourself. That's actually going to retain your autonomy as opposed to a guardianship option where you will lose your autonomy and your rights to sign for yourself because you've been declared by a court to be incompetent.
And nobody likes to go through it. And beyond just the initial appointment and trial to have that determination made, there's continuing work that the family then has to do. So whoever is appointed has to provide yearly or bi-yearly reports to the court on the individual's health, where they live, and they have to provide a full accounting. So they have to literally take their individual's checking account and change it over to a guardianship account, and then account for every penny that's spent. And courts will look at that, and if they see anything, might have you come back in and ask you questions about that. Whereas the power of attorney doesn't require that kind of oversight. And it keeps people, they have a lot more privacy that way.
I thought I might do something off the power of attorney and guardianship for a second too. I say, almost everybody is aware that when they have a last will and testament, that governs who gets your things if you pass away. Yeah. What many people do not properly understand is it's just as important to have all your beneficiaries sit correctly.
Yes.
Joint account holders, co-owners on real property, depending on how it's titled. All of these things are going to trump what's in your will. So if you have, and we've seen this come into the office, folks
Yeah.
come in, somebody comes in with a will from a parent that's passed away, and the will starts right away saying, this much money out of my life insurance proceeds goes to Bob, and this much goes to Tom. Well, that life insurance money very typically is not part of the estate. The will doesn't govern that, okay? When you have beneficiaries on a life insurance plan, that's a contract with the insurance company. They're going to, with a death certificate, they're going to cut that check directly to the beneficiary. It's never going to be part of the probate process. So it's very important that even when you write your will, when you say who's going to get what out of your estate, out of your money, your cars, your real property, that you make sure those things are titled in such a way they're going to be part of your estate, or if they're not and you want them to be, that you get that fixed.
Yeah, because and sometimes if you don't have the proper things, your money, your life insurance policy could go to someone else, maybe an ex-spouse. If your deed isn't titled correctly, we've had this happen where maybe a new wife, there's a second marriage, and the husband or the husband passes away, the wife comes in, and we start going through the questions, and while they didn't have any children together, he has an estranged sister. And so, unfortunately, without a last will and testament, Kentucky law governs how that property passes, and Kentucky law prefers bloodlines. So half of it goes to the spouse, but half of it then is the sisters. And that can cause a lot of problems because, you know, if individuals are estranged or if it's an ex-spouse, they may not be so apt to, you know, just sign that over to the current spouse.
And one of the more distressing conversations we have with people is they call to make an appointment, and someone has passed away, and they say, okay, Mom had a will. We've got the will, we're bringing it to you. It lays it all out. And they come in with a piece of notebook paper, and some things are written on it, but it's not done in any sort of way that would be legally binding. And they're very upset when we have to tell them, well, this isn't a will. Or the very common thing, actually, in today's digital world, is they found a form online.
Yeah.
They've printed off a form, they've filled in some blanks. Maybe they have or haven't. In many instances, they have not even, Mom hasn't even signed the bottom of that document. That's not a valid will. And they're like, and so the kids are saying, well, but it's instructive, like we can tell what she wanted. That's not how that's going to happen in court. The judges we either have a valid will or we don't. We don't have instructive documents on what to do when there is no will. So that often causes a lot of heartburn. When you have something handwritten out, and there are ways of having a holographic will that you can have a handwritten will that is valid, but you've got to meet all the statutory requirements for that to work, and it's an all or nothing proposition. You can't kind of have a will or have documents that kind of let people know what you want. You've either got to have it done all the way, or it won't be functional at the time you pass.
And it's really, really simple to set up a basic estate plan. We have ours, and it's something that you're never too young to get that plan in. We believe here in Shelby County, we set up our all law firm here. We don't believe you have to go to Lexington or Louisville to get the kind of quality legal advice that you need. So we set up here. We want to be here for you.
So if you want top-notch service with a personal touch, please give us a call.
Our phone number is 502-205-9005.